Today is session 4 in our Masterclass series on dismissals. So today we are talking about SOSR and statutory dismissal. So two of the potentially fair reasons for dismissal in one session. And SOSR is a really interesting subject. It's one that people think of as a bit of a catch-all. It's quite popular for discussion points with HR. So hopefully this will be an interesting session for all of you, and hopefully we can clear up a few sort of HR urban myths as well. So the cost of getting statutory issues wrong and why we have these two categories as potential fair reasons for dismissal. If we, for example, take on someone who doesn't have the right to work, then we can face a maximum civil penalty of £60,000 per illegal worker. And for a first breach, so a first offence, you could still be looking at £45,000. There's an ACAS uplift of 25%. And if we use fire and rehire incorrectly, there is also a 25% uplift there as well. So SOSR is not just a use this when nothing else fits reason. We have got statutory reasons. We've got SOSR as a potential reason, and people sometimes don't understand how they interlinked, but also how they are separate. But where we've got circumstances where people, for example, don't have the right to work, or where we can't agree with an employee in certain situations, this might be where we start to look at SOSR and statutory dismissals. So the rules are changing, as we've talked about in the previous sessions, because of the Employment Rights Act 2025. So from January 2027, the qualifying period is reducing from 2 years to 6 months. So almost every dismissal is going to become something that is potentially claimable. We're also potentially seeing the removal of the compensation caps. So again, unfair dismissal, which was generally seen as something that the cost for compensation could be relatively manageable. We could make commercial offers and settlement because we knew we had these caps. That is now also going, and the claim window for when people can bring claims is also being extended. So people are going to have up to 6 months after a breach to be able to issue a claim. Why SOSR cases are often exposed is the reason is often used incorrectly. So tribunals scrutinise SOSR decisions because they know it's used as a bit of a management and HR dustbin. So we know someone wants to go, we know we don't want to keep them anymore, and where it doesn't quite fit in with other categories, SOSR is often something that is used and therefore used incorrectly, because that's not what SOSR is for. And if you're new to this field, if this is your first webcast on a subject like this, SOSR stands for some other substantial reason. And if you listen to our podcast, you will potentially hear Ollie refer to it as SOSR, which always cracks me up a little bit. But that's what SOSR stands for, is some other substantial reason why we might be ending somebody's employment. So as we've said, day one, so the rights that someone is going to have when they've been with us for 6 months and uncapped awards are something that we're going to be facing, as well as heightened scrutiny. So we need to make sure that where we have cases where SOSR is a potential reason for dismissal, that we are auditing these, that we are making sure that we know what we're doing before we get to 2027. So how exposed do you think your business is to an SOSR or statutory dismissal claim? So take a moment, have a think and be honest. Have a think about which of these best described your organisation's current position. Is it that you're relatively confident in dealing with SOSR or statutory restriction dismissals? So do you have clear policies on them? Do you know when you would use them, when you wouldn't use them? Do you know when not to just default to SOSR and how we work through these as processes? Are you a bit more cautious? So you've handled 1 or 2 of these, but we're not always sure where SOSR ends, what sort of process you need to follow, whether it's the same as disciplinary or capability. And also, or are you concerned? So you've dismissed someone for, say, a trust reason or because of a customer complaint, but you didn't really know how to handle it or whether you followed a fair process, or you're just unsure. You've never thought about it. You've never had to use it. You're not in a situation either way you're doing right to work checks, and this would trip you up, and therefore you've got that significant other risk. And this session couldn't come at a better time for you. So drop it into the chat here, where you currently sit, whether you're confident, cautious, concerned, or unsure. And we'll come back at the end of the session and we'll think about where you sit and if you've got a little bit more confidence towards the end. So just scanning down through the chat. So cautious, unsure, unsure, cautious, unsure. Yeah. So of all the sessions, so when we look at conduct, we've looked at capability, we've looked at redundancy. These are the ones that always often raise the biggest question marks, because SOSR and statutory restrictions are significantly less used than the other reasons. SOSR rears its head now and again. Statutory dismissals are quite rare, not because it doesn't happen, but just generally because we've had this window where if someone works for us and there's a statutory reason why we need to dismiss them, it tends to arise quite early, so it's before that 2-year limit, and we're not really thinking about fair reason for dismissal. We're just thinking this person needs to go because it's no longer lawful to employ them. With that limit coming down, I do think we are going to be seeing more of these. And as people are becoming more switched on to the right to work issue and how much of an issue this is and how it could impact directors from a criminal perspective, but also those enormous fines, we are seeing more and more people now are getting on board with the fact that they have to do these checks, and also the repeated checks for people who were on temporary visas and things like that. So you could have someone who had the right to work when they started with you. That right to work lapses. We're doing our regular checks. We've seen it coming. That person still doesn't have the right to work. We're potentially going to be dismissing them on a statutory basis. So in the series overview, where are you? So we've done conduct, we've done capability, we've done redundancy. If you've missed those sessions, they are available on demand. We're in session 4, so SOSR and statutory dismissals. And the next session that we have is the secrets to retention and recruitment. So we're balancing out our sessions on dismissal and how to dismiss employees with some real positive messages around how we can recruit properly, how we can retain people, good onboarding. And we have a fantastic guest speaker for that one as well. So Kath Patterson, a recruitment expert, is going to join us for that session. So it's one not to be missed. Make sure that you are booked onto that session. What you're going to take away from this session, hopefully you'll be able to distinguish a true SOSR dismissal, so separate a genuine SOSR from a sloppy conduct or capability case that's been dressed up to avoid a proper process. Sorry, I need a bit more caffeine this morning. You're going to identify the 4 SOSR subcategories, so third-party pressure, breakdown of trust, imposed contractual changes, which we are going to approach with a lot more caution because of the fire and rehire restrictions, and reputational risk and the case law that defines them. We're going to look at how we can spot statutory restrictions and also how to run a defensible process. So we are going to have an available checklist to download. So the link, I don't think will be in the chat. This is going to come out in the emails that we send afterwards. So we will have a checklist in the email for you to download. So look out for that. If that is something that will interest you, again, drop it in the chat just so that we know that we are sending out relevant content and it's something that's going to be useful for you as well. So where does SOSR, excuse me, and statutory restrictions sit in relation to the Employment Rights Act? Well, Section 98 of the Employment Rights Act gives us 5 potentially fair reasons to dismiss. So I'm not going to go into this in loads of detail because we've done it in the other 3 sessions already, but if we want to dismiss an employee, there's 5 reasons that we can do so: conduct, capability, redundancy, SOSR, and statutory reasons. If it doesn't fit into those 5 reasons, it's not a potentially fair reason to dismiss. We're already on to an unfair dismissal. So every dismissal that we do must first establish one of those reasons. And we can't combine the reasons, we have to pick one. So we have to nail our colours to the mast and make a decision over what is the actual reason why we're dismissing an employee. And what tribunals are very good at doing is unpicking our reasons. So say, for example, if we have someone where their capability is an issue, but they're off sick, they've raised agreements, this person's a bit of a nightmare, and we've got concurrent processes running, and we know it's going to last for months, and we shove them into an SOSR meeting and go, this relationship's not working, and we dismiss them. A tribunal is going to identify that as an employer who didn't want to go through a capability process, that the real reason for dismissal should have been capability, not SOSR, and that we've taken a shortcut. And that's potentially an unfair dismissal. So even if we've labelled it with a potentially fair reason, a tribunal is going to get to the bottom of whether that fair reason is actually accurate in the circumstances. So what I will often get asked is where we've got someone who either face doesn't quite fit for whatever reason, so there might be personality clashes going on at work, might be some capability issues, low-level conduct stuff, but not enough to dismiss, and then they try and shove them after, say, some informal conversations or some low-level processes into redundancy. It's really transparent, so we've got to be really, really careful with this stuff. So what's also critical is this is just the starting point. So this is just a potentially fair reason. We still then have to follow a fair process, and we still have to ultimately, at the end of it, make a fair decision. Just having the right label on a dismissal isn't enough. So we've had a quick poll while I've been wittering on. What is your biggest risk area right now when it comes to dismissals? Is it managers skipping processes because the outcome is obvious, confusing SOSR with conduct or capability, right to work or license issues, customer client pressure situations, or we honestly don't know? Managers skipping process because the outcome is obvious is not a surprise. And it's the reason why these sessions are all being turned into e-learning courses. And it's why we are expanding our e-learning library to include sessions for managers and HR. So if you're HR, you can top up your CPD, you can take some refresher courses, and just make sure that you're up to date with your knowledge. But then if you have a manager who you think actually needs to understand stuff that we've talked about in these sessions, those e-learning courses will be available for your managers so that they can sit through a session like this and understand what they should and shouldn't be doing. So SOSR versus statutory, what's the difference? So statutory restriction is when continuing employment with someone would actually breach the law. So if someone, for example, has lost their right to work in the UK, then it is illegal to employ them. So we're not dismissing them for conduct, we're not dismissing them for capability, their role still exists. It could potentially be some other substantial reason for their employment ending, but actually, when we think about the reality of the situation, we will be dismissing that person because they no longer legally have the right to work. There is a legal reason that prevents them from working for us. So other common ones are we have a driver who has lost his driver's license. It's no longer legal to employ that person to drive for you. If someone's been struck off a professional register, if someone's been imprisoned preventing performance. Now, yes, it's potentially illegal to employ that person, or it's unlawful because they're in prison, but also that is one that could very easily sit in SOSR. So there is some other substantial reason why that person can't be employed. So where I would probably use statutory for someone who's been imprisoned is perhaps if you've got someone who is now on, for example, the sex offenders register and you work with vulnerable people, that is a statutory reason why someone is potentially unable to work within your workforce. It's a very, very narrow gateway, this one. The restriction has got to be more than peripheral to the role. It's got to absolutely go to the heart of it. And we've also got to consider other alternatives and follow a fair process. So say, for example, we've got someone who has lost their driving license. Are we able to offer them an office-based role? Is there something else that we can apply their skills to rather than immediately going to dismissal? However, where we've got the example of someone who has lost the right to work, that's absolutely a bar. They are going to lose their employment. But I would still be holding a meeting with that person. It's just that we're not going to be scheduling it 6 weeks down the line. If we find out someone no longer has the right to work, that's probably going to be an immediate meeting. Listen to make sure, one, that we've identified the correct person, particularly in large workforces. Two, understand what's been going on. But then ultimately, that's going to be a pretty swift dismissal to make sure that we're not in breach of Home Office rules. As we've got a question there. Do you have to go through a process for statutory dismissal? So I would still go through a process, even if it's going to be a very quick one. I wouldn't pull someone off the say a work clause 4 and just go, you're out of here. I would still have them into a meeting. I would still explain the issue, remove them from site and inform them that the likelihood is that their employment is going to be terminated immediately. It may well be that you need to ring your lawyer, ring your legal advisor, perhaps make some inquiries with the Home Office. This is all going to happen hopefully in the same day, and then letter email out terminating employment. So you're still following a kind of process, and you'd probably even give that person the right to appeal just in case there's something that's been missed. And then question, does the statutory restriction include teachers who don't, for example, have QTS or struck off? Yes, potentially. If you've got a teacher who's been struck off, you're not going to be able to employ them in a teaching role. Depending on what they've been struck off for, there is still, then you need to be looking at whether there are any other alternatives. If it's conduct based, so say, for example, you've got a teacher who has been violent with a pupil, and they're struck off. One, if they're struck off, they're not allowed to be a teacher anymore. But also in that sort of situation, you'd be looking at gross misconduct as a conduct dismissal anyway. It depends which comes first in terms of the strike off or you discovering what the reasons are. If it was in a previous role and it's a teacher that's, for example, that you've recruited and you weren't aware of it. But yes, it could include a teacher who has been struck off. SOSR, so substantial reason, where we're not covered by the 4 named categories. So where it's not redundancy, it's not capability, it's not conduct, it's not statutory restriction, but we have some other substantial reason why we can't employ someone. And the clue's in the name here. It's a substantial reason why we can't continue to employ them. So this could be things like third-party pressure. So where you have a client who falls out with a staff member, and they're saying, I absolutely cannot work with this person anymore. You're a small business. Perhaps this client is responsible for 75% of your income and you've got nowhere else to put that employee. Maybe it's, but that's substantial enough to end their employment. A significant breakdown of trust and confidence. Imposing contractual changes. Again, caution here because of fire and rehire stuff. Reputational risk and personality clashes between staff members. So for example, in the past, I've used SOSR where we had a husband and wife working together, very small workforce, husband and wife split up, got divorced, and it was a nightmare at work. We removed both of them. This is quite a wide gateway, so lots of different facts can come in here, but tribunals will scrutinise these heavily because it is seen a bit like the HR dustbin. So we are still expecting a fair process here. So mirroring conduct capability, so inviting to meetings, allowing someone to have their say, investigating issues or relationships where we need to before decisions are made, and making sure that the decision that we come to is fair in all the circumstances. So watch out for overlap. So a statutory restriction case where a restriction is found not to apply. So for example, a mistaken belief that right to work is applied could potentially still succeed as an SOSR. So I've got another question here. So where does sickness fall? For example, dismissals being unable to sustain required attendance levels. So someone who has lots of sickness over a long period. I'd still generally be dealing with that one under capability, because the reason that we're dismissing that person is because they're not capable of fulfilling the contractual role or the contractual hours that we have asked them to do as part of their employment contract. SOSR is sometimes used by people in sickness absence cases because they feel potentially a little bit nervous about applying capability to it. But when we apply our mind to it and think, what is the real reason that we're dismissing this person? If it's because of sickness and absence, the likelihood is it should be falling into capability unless the case has some other quirks to it. So if a candidate lies about their location in their application, so location was a requirement in the hiring process and later find out where they actually live, can we withdraw the offer based on SOSR? Yes, potentially, though if they've been dishonest, again, are we dismissing them because they're in the wrong location, which could be SOSR, but are we dismissing them actually because they've been dishonest with us? That's conduct. So again, it's not always straightforward. So when I talk about identifying the potential fair reason and people think, oh, that's really straightforward, I know why I'm dismissing someone, these are the cases where we have to be really honest about, right, what is it that's got under our skin here? Why are we removing this person? So in that case, I would be deciding, is it because they've lied and we can't trust them so early in the process? Or is it actually the white lie doesn't really bother us, but the location is such an issue that we can't continue with this? Then that would be SOSR. How do you apply a process if someone is imprisoned? By correspondence, or they can send a proxy. Imprisonment cases are complicated. I would suggest a legal advisor if you're using those, but it can certainly be done by correspondence or by having them send a proxy, and I have done both. So the fairness test, so same test, no shortcuts. We have to have a genuine reason. So did the employer genuinely hold SOSR, a statutory reason as the reason given? So what I've just talked about. So it must be the actual reason in your mind at the time of dismissal. Is it a substantial reason? Is it enough to justify dismissal? So trivial reasons are going to fail here. Was it a reasonable response? So was dismissal within the band of reasonable responses open to a reasonable employer? Hopefully all this is now becoming rote after the last 3 sessions that we've done on this. Fair procedure, so the ACAS code applies. So investigate, notify, hear, decide, appeal. And there's no exceptions for SOSR we should be following, even if we need to abridge it, even if all this needs to be quite close together because the situation is quite urgent, we should still be doing what we can to try and follow a process to make sure that it is fair for the individual, because we do make mistakes. There can be cases of mistaken identity or documentation not being entirely right, and processes are designed to catch those so that if we make a mistake before dismissal, we can halt a dismissal that would otherwise be unfair. Make sure that we consider alternatives. So can we redeploy? Can we make adjustments? Is there a different role that could be offered other than dismissal? and making sure that we're not just caught in that tunnel vision, that we've got our blinkers on and we're just thinking, how do we get to dismissal, that we have got that sort of peripheral awareness, and that we are making sure that we are investigating properly and taking in all the relevant facts. So a case that I've advised on with somebody before is where we had a driver who lost his driver's license. He was adamant that he could work in an office-based environment. They did a bit of a trial. It was very, very clear that he wasn't capable at all for an office-based environment. They gave it a go. So he had 2 or 3 weeks to see if he could settle in a bit of training. It didn't work out, and his employment was ended on the basis of SOSR. So when the law won't let you keep them. So these are relatively more straightforward than the SOSR. So it's potentially fair where continuing employment will contravene a duty or restriction imposed under a statutory enactment. So the 4 classic scenarios: loss of right to work, loss of driver's license, loss of professional registration, or imprisonment where the sentence makes performance impossible. So where we're talking about frustration of contract, SOSR can be used if frustration is not entirely made out. So for SMEs, we've got a risk flag here. So many SMEs will jump to dismissal the moment, for example, that a license is lost or a visa expires, and tribunals do at first expect you to check whether the restriction genuinely prevents continued work, which often loss of right to work will. But visas can be quite complicated. So someone might have the right to reside, but they don't have the right to work. So making sure that actually it is the right to work that they don't have before we dismiss, because if we go, oh, well, you've lost, I don't know, an element or condition of your visa, but actually it doesn't affect their right to work, that would be an unfair dismissal. Whether redeployment is possible, whether short-term leave is feasible, and skipping those steps could potentially be fatal. So when I was a trainee lawyer, so, all of 10 minutes ago, I was working on a case with a national supermarket at the time. And it was uncovered that a group of pharmacists in one particular store, no, it wasn't pharmacists, it was opticians in one particular store, hadn't had the DBS checks done, which was dropping the ball on the behalf of the supermarket. It wasn't them that was at fault. And the initial query came in to the legal team. They wanted to dismiss them under statutory reasons. We suggested that they just put them on paid suspension for a couple of weeks whilst the DBS checks were sorted out. So it's making sure that we don't just jump to that dismissal, that we look at other potential alternatives. So should an employee be paid for dismissal for notice under SOSR? Yes. The only time that we don't pay notice would be in a conduct dismissal. Now, it may be that if you've got contractual notice periods, so say, for example, statutory only requires you to give a week's notice, your contracts say that you're going to give 3, you could look at a carve out so that if there are any statutory reasons or perhaps a substantial reason why someone's employment needs to end, that you'd revert back to statutory notice so that you're not having to honour those long contractual notice periods, but you need to make sure that your contracts are updated, because obviously the fire, rehire, changing contractual terms for existing employees is going to get harder. Cases to be aware of. We're a bit short of time, so I'm going to skim through this, but the notes will be circulated, obviously, with the session afterwards. So cases that you should be aware of. So an employer who dismissed believing an employee had no right to work when in fact somebody did. A genuine mistaken belief that continued employment would breach immigration rules, a bus driver who lost his license and the statutory restriction was engaged. The dismissal was fair where the role inherently required driving, and a restriction that must bite on the actual job being performed, not a peripheral aspect. So if the prohibited activity is incidental to the role, can we just remove that aspect of the role and actually, most of the role is still intact? It may well be unfair to dismiss in those circumstances if the substantial part of the role remains. So the catch-all and why it catches people out. So SOSR is a genuine substantial business reason that doesn't fit conduct capability, redundancy or statutory restrictions. It's been recognised by the courts and its RS components. Now, ironically, this is a case where an employee refused to sign restrictive covenants. I think they were being promoted or taken into a more senior role. The fact that they wouldn't sign restrictions going into a role where they would be exposed to confidential, sensitive information and customers was found to be enough that there was sort of a breach of trust in that situation, and the dismissal was fair. Obviously now, Fire and rehire based on terms, we're on sketchier ground here. So when we're looking at promotion and introducing new contracts, we're going to have to be very, very clear that if promotion is conditional on new contractual arrangements, making sure that's in our policies and procedures and that it's not perceived to be a fire and rehire issue. So what SOSR is not a way of running not running a proper conduct or capability process, and the label, it's not a label that you apply because you don't know what category a dismissal sits in, and it's not a justification for skipping the ACAS code. So if your dismissal letter says I'm dismissing you for SOSR without actually identifying what the substantial reason is, it's already failing. And if when you're explaining what the substantial reason is, you're thinking this feels a little bit more like a sickness issue, put the brakes on, get some advice, because it could well be that you've drifted down an SOSR corridor when actually it should be something a little bit different. So where it often lands in practice, so third-party pressure, so customer, client, or a regular demands that an employee is removed for whatever reason. It's common in care, security, and regulated sectors. Employers must scrutinise the demand and consider redeployment before acting. So it has found in some situations, to be fair, where an employee has been removed following falling out with a customer. And in smaller businesses, it's almost a little bit easier because redeployment can be a bit more difficult. But you can't just have a knee-jerk reaction to that request. You've still got to consider it fairly, see if there's a way to mediate that relationship, and if there isn't, where else can we put this person? Breakdown in trust and confidence. So working relationship is irretrievably broken down. So it's high risk because tribunals will look at whether you as the employer caused that breakdown or contributed to that breakdown, or whether actually this is us trying to shortcut a grievance process, which is often where this one will arise. Imposed contractual changes, so employees refusing to accept new terms, hours, locations, duties, pays, and dismissal and re-engagement is now governed under the new statutory code. And remember, there's an uplift here. So if we're in a situation where a company is in dire financial straits, so we think that we hit that exception that's going to allow us to do the forced contractual changes, it could well be then in that situation, SOSR will still be a fair dismissal, but this is a very high risk area now. You need to make sure that you take advice on it. Reputation or external conduct. So if you've got someone whose off-duty conduct has been very, very poor and it's going to cause reputational damage. So say, for example, you've got someone who's been engaged in some sort of criminal or very, very poor activity. They've ended up in the press or all over social media, and it's very obvious that they work for you. SOSR could be an option. There's a case on this from years ago about, I think it was another supermarket that dismissed someone for playing around with a plastic bag, and it ended up on YouTube, and they said there was reputational damage. And I think when they analysed it at tribunal, only like 12 people had watched the video, and about 6 of them were on the legal team, and it was found, well, it couldn't possibly cause the reputational damage that the company was saying that it would. So we have to actually be realistic and objective about this. Are we jumping to reputational damage? If we do think the reputational damage is real, we need to be very clear about how we're able to describe that, and that it is credible. It's not just a dustbin for things where we think someone has behaved inappropriately. So when a customer or client demands removal, I've already kind of talked through this very quickly. The tribunal's got to consider the injustice to the employee, not just the commercial pressure. A reasonable employer will push back to some extent, but also look for redeployment and use dismissal only as a last resort. So third-party pressure can be SOSR, but you must conduct your own inquiry as well. You can't just rubber stamp the third party's decision. So it can't be used as a kind of backdoor to get somebody out by asking a customer to have somebody removed. And dismissal was only fair in one of these cases because the employer had genuinely tried to find alternatives first. So 4-step test: is the third party's objection genuine and sustainable? Has the employer pushed back and tested the demand in writing? Is redeployment to a non-affected role possible? And has the employer followed a fair process with the employee? They've not just responded to the customer. So when the working relationship is truly broken down, so where we've got personality-based breakdown where staff fall out, that can be SOSR, but you must evidence the breakdown, show that mediation has either been considered or attempted, redeployment, coaching. So what have we done to try and fix this clash where it exists in the workplace? Can we move people around? Can we bring a mediator in? Can we just give a bit of time and see if things cool off a little bit? So in the North Glamorgan NHS case, so SOSR was only made out because the employer had genuinely investigated and exhausted all alternatives over a sustained period. And then in Phoenix House, there was a post-grievance or post-whistleblowing breakdown where arguments are particularly risky, because if you've got someone who's raised a grievance or blown the whistle, and then it's caused a personality clash with another employee, perhaps who was involved in the investigation, and someone's dismissed because of that personality clash, that could potentially be a dismissal. It's a detriment of blowing the whistle. So again, very, very high risk. We need to be careful with those. So 4-step test: is the breakdown genuine and evidenced? Or is it just shorthand for we don't want them here anymore? Did the employer cause or contribute to the breakdown? Because again, if we've caused this issue and then we're dismissing to fix it, it's not really fair. Has mediation, redeployment, role redesign or coaching been genuinely tried, and has a fair process been followed? Refusal to accept new terms. So we're going to do a whole session on the fire and rehire stuff. So this one just kind of comes with a bit of a warning that if you are attempting to use SOSR in a situation where it's because of contractual terms, my suggestion to you would be don't take specific legal advice on this, because not only is it engaging the unfair dismissal stuff, but we've also got the things around the new statutory fire and rehire. There's potential uplifts here. So put the brakes on in this situation. Make sure that you're taking advice, because there is a significant process that you're going to have to follow if this is going to be a fair dismissal. So third-party pressure, bit of a case study for you here. So Heartside Cleaning is a 12-employee commercial cleaning company. This is a fake situation. So the client emails that we want person X removed from site, full stop. If she's on site on Monday, we are going to pull our contract. The tempting or risky approach is the owner emails X on the Friday and says the client doesn't want you back. Sorry, we're paying you your notice. No meeting, no investigation, no alternatives considered, no appeal offered. Tribunal exposure here would likely be unfair dismissal breach with an ACAS code 25% uplift, because we haven't followed any steps. There could potentially be discrimination if the client's complaint is connected to a protected characteristic. So if it's race, gender, disability related. So estimated cost 15-25 grand in compensation or more, plus legal fees and plus discrimination uplift. So easily could be a 50-60,000 pound claim. The defensible approach: push back to the client in writing. What specifically is the issue? We need you to give us a bit more information here. We're not saying we won't cooperate, but we need to understand what this person's done for our own internal processes. Hold a meeting with person X and share the client's position and hear their response and take it clearly. Look for redeployment if we can. Even if it's temporary, and if the dismissal is the only option, they get notice of the issue, they get the hearing, they get the written outcome, and they get the right to appeal. So statutory restrictions, 3 variations on the same thing. So I'll leave these case studies into here so you can have a read afterwards, but these go into a bit more detail on the things that we've raised before. So delivery driver who loses their license, a visa expiring within short notice, and then someone who is convicted of a criminal offence. So breakdown of trust, another case study. We've got Cavalier Engineering, so a 20-employee engineering firm. 2 senior staff have been at war internally for 18 months. Mediation has failed and the owner concludes that one of them has to go. So again, the risky approach: owner picks the person he finds more difficult to manage and dismisses, citing irretrievable breakdown. There's no documented investigation, no evidence of alternatives, and no independent input, and no hearing. No documented timeline of what was tried. There's an arbitrary selection between the 2 parties. And if the dismissed employee has raised any grievances, that could also be an additional risk if there's anything that could constitute whistleblowing or a statutory right in there. So the defensible approach: we document the timeline, mediation, role changes, separated the individuals or separate reporting lines and coaching. External assessments, and maybe get independent HR or mediator in to confirm the relationship has irretrievably broken down. Hold a meeting with each employee separately to share the proposed approach or hear representations. Consider whether one's party's conduct is the dominant cause. So if we have an aggressor, if so, conduct might be the better reason to dismiss. If not, SOSR may then be the genuinely better answer. So the 5 traps that catch small businesses: 1, defaulting to SOSR for awkward cases; 2, skipping the process because the reason looks obvious; 3, right to work shortcuts, so failing to follow the checks before somebody starts work. So even if we dismiss that person, if we have employed them without doing those right to work checks, then we are in trouble and we're potentially liable for those fines. Acting on customer demands without inquiry, and using fire and rehire as a first resort rather than a last. So your 7-point test before you hit press send on any SOSR or statutory dismissal, have I named the actual reason? Can I clearly describe what the problem is here? If I can't get past it's SOSR or it's statutory and I can't explain it, we've got more work to do. Is it genuinely the right category? So when we then see that explanation following those terms, is it leaning actually into one of the other categories? Have I documented the alternatives I've considered and why they don't work? So why redeployment won't work? Why changing that role isn't going to work? Have I run an ACAS process in full? Have I invited them to a meeting? Have I had the meeting? Have I given them the reasons and explanation in writing? Have I given them the right to appeal? For statutory cases, is the restriction genuinely engaged? Make sure that we have got our facts straight. For SOSR cases, did we cause the breakdown in what we're relying on? And 7, if I had to defend this in front of an employment judge tomorrow, do I have all the paperwork? Do I have a full timeline, a full chronology of everything? And do I feel that I could explain this? And when I explain it out loud, is an objective and reasonable person going to think that this was a reasonable thing that we have done? So action to take before next Monday morning. If you've had to miss any of this session, listen to it back. If it's made you think, actually, I need to go over conduct capability or redundancy again, have a listen back to those. Download our checklist. And then if you're still not sure and think, you know what, our stuff's all over the place. I don't know if we're doing our right to work checks properly. I don't know if my managers are trained appropriately on these things. I feel like actually we need a bit more support with our advice and our admins everywhere. Well, look, we're here to help. So we have a new unified approach to our offering. We now offer in one subscription, one price. You get e-learning, so training for all of your staff and managers. Our HR software, if you want it. If you're already using another system, it doesn't matter. Then the subscription's still available to you. Our human advisors, so you get me, Michelle, and Sophie, but also our AI advisor tool is about to be released. It also now comes all wrapped up in insurance protection as well. So if the worst happens, it will cover you for your legal fees and any compensation that you need to pay out. So if this is of interest to you, if you think, you know what, I finally need to get my act together, just get a bit more organized, and I want everything in one place with people who know what they're doing, then book a demo with us and get in our diary, because we are super busy at the moment, but we love welcoming new people on board as the Heroes family continues to grow. If you want the statutory and the SOSR checklist, that will be coming out in the emails as well. And don't forget to sign up for session 5. It's not wrongful dismissal and notice. It is retention and onboarding. And the wonderful Kath Patterson is joining us for that as well. And that will wrap up our dismissal masterclass before we move on to our next masterclass series. If you missed the first masterclass series, that was on the Employment Rights Act. And as I say, all of these sessions are being converted to join our e-learning catalogue as well. So thank you so much for joining us on this session. We have gone through at 1,000,000 miles an hour as usual, so feel free to watch it back a little bit slower, take any notes that you need to, and please don't hesitate to book that intro call with us and get in the diary and see how we can help you. And if anybody does have any questions that we haven't got to, we'll go through the chat, we'll send those out in the email, and if anybody feels that they need to talk to me about anything that's a burning question, then don't hesitate to pop an email over and we can put you in my diary as well. Thank you so much. It's lovely presenting to you all as always, and it's nice to see so many familiar names as well. That's the end of this session. You have got your mornings back, and I look forward to seeing you on the next session soon.